I'd like to thank the Law, Gender, Collectivity Research Unit for the kind invitation to speak with you this evening, and Johanna and Patrick in particular for making it so easy for me to come. I was lonely. I've been working in my attic for 4 years and I needed to get out. So this is great. It is a real pleasure to be with you here this evening to discuss the European Union's multifaceted and human rights approach to human trafficking. That's how they call it, and that's what I want to explore. The European Union has led the way in adopting region-wide binding legal norms to address human trafficking. Initially, its governing institutions approached human trafficking as a problem of organized crime and illegal immigration, focusing almost exclusively on sexual exploitation and prostitution of women. By 2012, however, labor trafficking had moved onto the EU's agenda. Its governing institutions embraced a multifaceted approach based on human rights and systematically embedded in multiple policy instruments in areas ranging from security to migration, justice, equality, anti-discrimination, fundamental rights, employment, development, research, humanitarian aid, and even fisheries. This evening, I want to explore what the EU's multifaceted approach to human trafficking based on human rights entails. I argue that the legal assemblage of jurisdictions helps us to understand how the EU's approach to trafficking hitched human rights to a carceral governance agenda and led to profoundly gendered strategies for addressing sexual and labor exploitation, respectively. I focus on the European Union for two reasons. First, because of its much heralded human rights approach to human trafficking. And second, because it disrupts the conventional legal default jurisdiction that links sovereignty to territory by creating plural and hierarchical borders between member states of the EU, new accession countries, candidate countries, and countries outside the EU. The treaties that make up the EU allocate institutional jurisdiction known in the EU as competences on a scalar basis between EU institutions and member states. A key feature of EU integration has been the separation and sorting of different institutional jurisdictions into different scales that are associated with different governance technologies. The EU's jurisdictional assemblage has shaped its approach to human trafficking. Since 1990, the EU has gone through 3 episodes of significant constitutional change that have altered the scalar and governance dimensions of its jurisdiction and increased its authority over human trafficking. The Maastricht and Amsterdam treaties, which were adopted in the 1990s, triggered a project of criminal law harmonization and strengthening EU external borders. The third constitutional moment, the Lisbon Treaty, which came into effect in 2009, supported a counter-movement boosted by the Council of Europe's Human Trafficking Convention to protect the rights of victims of trafficking. But it was the dramatic expansion of the EU to include former socialist countries that led to greater attention to the problem of labor trafficking. Today, I'd like to mine the legal assemblage of jurisdiction for the purpose of theorizing governance, using the EU's multifaceted and human rights approach to trafficking law as my example. My lecture progresses in 3 sections. First, I explain what I mean by the legal assemblage of jurisdiction. Second, I sketch how in the mid-1990s human trafficking emerged as a global problem. And third, I analyze the EU's approach to human trafficking through a jurisdictional lens. I argue that although the EU characterizes its multifaceted approach to human trafficking as based on human rights, trafficking is a problem for the EU to address because it is seen as a crime that crosses national borders. Problems that cross national borders, such as transporting people illegally to exploit them, are particularly troublesome because they do not fit into the default spatial format of legal jurisdiction, which is national and territorial. They require a different and international scale of governance. Lawyers tend to see this international jurisdiction as operating at a higher level where processes play out. Instead, social geographers claim that what makes an issue international is the relationships, the network of actors, institutions, practices, and discourses within which the issue is enmeshed. From a relational perspective, scale is considered a technique of governance. Understood in this way, scale draws attention to the network nature of global governance. Jurisdiction also importantly refers to the power of law to act and the scope of an institution's authority in relationship to other institutions. Combining the scalar and governance dimensions of jurisdiction, Mariana Valverde, an excellent socio-legal scholar, treats jurisdiction as a complex legal assemblage that operates as a kind of sorting mechanism that allocates a problem, a particular form of unfree labor, for example, to a specific authority for resolution. Legal systems are made up of several different institutional jurisdictions or regulatory domains, such as criminal law, commercial law, labor law, and constitutional law. Each jurisdiction involves assumptions about the nature and causes of a problem and the governance goals, strategies, and techniques, which include matters such as burden of proof, remedies, operatives, and forms of adjudication and dispute resolution. Criminal law's principal operatives, for example, are police and prosecutors. The burden of proof is on the state, and the standard of proof is beyond reasonable doubt. Punishing perpetrators is its main goal. Under human rights law, by contrast, commissions, tribunals, and non-governmental organizations predominate. The goal is to protect and compensate the victim, and often all the victim has to do is establish a prima facie case of harm. Jurisdiction determines which authority can lawfully exercise power over a specific subject, and in this sense, it is the governance of legal governance. It is the process by which governance projects are differentiated and kept from clashing as they are sorted into their proper slot. Jurisdiction establishes which state or supra or subnational institution in a federal jurisdiction like Germany or Canada has legal authority over a particular issue, whether the delegation of authority to other systems is lawful or unlawful, and which of the domains within a legal system, commercial, criminal, or labor law, for example, has authority over a specific matter. The beauty of jurisdiction as a sorting mechanism is that once a social problem has been diagnosed, it's been framed, and the legal solution has been developed, questions about the nature of the problem or how best to deal with it are no longer relevant. The assignment of jurisdiction transforms a political conflict over the goals and technologies of governance into a neutral and quotidian process of sorting subjects into the appropriate legal category. I use the legal assemblage of jurisdiction as a framework to untangle the solutions the EU has adopted to resolve the transnational problem of human trafficking. The collapse of the Soviet Union in the early 1990s triggered fears that organized crime was threatening national security by undermining governance and territorial integrity. Sensational media reports of women and children trafficked into prostitution by criminal gangs circulated widely in the mid-1990s. Developed states, especially those in the EU and the US, linked human trafficking to other crimes, treating it as part of a broader problem of combating transnational crime and criminal networks. In 1994, the United Nations responded to states' fears that organized crime was threatening their sovereignty by convening a world ministerial conference on organized transnational crime. This conference set in motion a process that resulted in the UN's adoption in 2000 of the Convention Against Transnational Organized Crime and its supplementary protocol to prevent, suppress, and punish trafficking in persons, especially women and children. The Human Trafficking Protocol was one of several optional protocols on different topics such as firearms and smuggling adopted at the same time. The 2000 UN Human Trafficking Protocol was a palimpsest, a series of international treaties adopted in the first half of the 20th century formed its gendered and racialized canvas. Beginning in 1904, a handful of mostly Northern European countries proposed a series of international conventions to address the problem of white slavery. A panic around European women being procured to work as prostitutes in the colonies, which merged with ongoing moral and public health crusades to stop prostitution, provided the impetus for these international conventions. They were informed by a highly gendered notion of moral purity and a view of migration as a corrupting influence. The idea behind them was to use the criminal law to reduce the supply of trafficked women and girls by making trafficking a criminal offense. The term white slavery, with its racialized connotations, was dropped by the League of Nations in 1921. But it was only in 1949 when the United Nations adopted the Convention for the Suppression of the Traffic in Persons and of the Exploitation of the Prostitution of Others that men were treated with women and children as potential victims. This convention also criminalized all forms of procurement and exploitation for the purposes of prostitution, regardless of the consent of the person who had been trafficked. Both the early trafficking conventions and the 2000 protocol are lodged in the domain of international criminal law and animated by concerns about prostitution and migration. But what distinguished the 21st century protocol from its forebears was its alignment of criminal law with women's rights and its emphasis on human rights. Influential women's rights organizations that advocated using the criminal law to tackle sexual violence and to protect women's rights were instrumental in forging the connections between sex trafficking, violence against women, and human rights in international law in the 1990s. However, they failed to resolve the controversial relationship between prostitution and human trafficking, an issue which divided the women's movement, civil society organizations, and nation states, and still continues to divide all of these groups. The issue is so divisive, it threatened to derail the UN's Human Trafficking Protocol. Whether prostitution without coercion was a form of exploitation was at the heart of the dispute. The impasse over the status of prostitution was broken by adopting a definition of trafficking in human beings in the United Nations Protocol that expanded exploitation beyond prostitution to include forms of exploitation such as slavery and forced labor. Article 3 of the Trafficking Protocol defines the crime of trafficking in persons as consisting of 3 elements: an action, means, and a purpose. The action element requires some type of movement, and the means entails that some form of coercion or abuse of power must be involved. But instead of defining exploitation, which is the purpose element of the crime of human trafficking, the protocol simply lists specific examples of exploitation, such as forced labor and slavery, that function as minimum requirements. The definition, which refers to both prostitution and sexual exploitation, is equivocal about the relationship between prostitution and sexual exploitation. Essentially, the protocol's broad definition of human trafficking delegates the resolution of the controversial issue of the relationship between prostitution and sexual exploitation to member states. In 1989, the European Parliament adopted a resolution on the exploitation of prostitution and the traffic in human beings, urging those member states that had not already done so to ratify the 1949 UN Anti-Trafficking Convention, which equated all prostitution with exploitation. Fears of a Natasha trade in women trafficked from Eastern to Western Europe harken back to historical understandings of white slavery centered on European women trafficked in Europe and to the colonies. The European Women's Lobby, a feminist umbrella organization funded by the European Union, was crucial in framing human trafficking at the European level as a matter of women's rights and part of the broader agenda to address violence against women and to promote gender equality. It viewed prostitution as exploitative per se and advocated its abolition through policies criminalizing the demand for sexual services as part of the solution to the problem of human trafficking. Although organizations that supported sex workers' rights stressed coercion as a critical component of trafficking, the European Women's Lobby exerted a great deal of influence over the EU's anti-trafficking policy. In the 1990s, all three of the EU's governing institutions framed human trafficking in terms of sexual exploitation and illegal immigration, best tackled by criminal law and securitizing borders. Reports of between 200 and 500,000 women and children trafficked each year into the EU circulated widely, and the numbers took on a life of their own. The figure of the migrant sex worker came to personify anxieties about national identity and sovereignty in Europe. Initially, the EU's anti-trafficking actions were restricted by its limited jurisdiction over criminal and immigration matters, matters of increasing prominence both for EU institutions and member states, because the Schengen Agreement, once it came into effect in 1995, would abolish internal borders between EU member states. In 1993, the Maastricht Treaty gave EU institutions authority over police and judicial cooperation in border control, asylum, and migration policy. However, since member states had primary jurisdiction over criminal and immigration matters, EU institutions were relegated to a secondary role, dealing with those matters with a transnational dimension. Anita Gradin, Sweden's first European commissioner, was pivotal in characterizing human trafficking as a policy issue that the EU could and should tackle. Responsible for immigration, home affairs, and justice from 1995 to 1999, she rejected the idea that there was no legal basis for the EU to take up the issue of human trafficking, claiming that it was clearly a matter of cross-border crime and within the EU's jurisdiction. The 1997 Treaty of Amsterdam opened the EU up to the possibility of negotiations for common policies on criminal justice and immigration. Even though the EU had a legal basis for developing criminal and immigration laws relating to human trafficking, member states continued to enjoy a great deal of leeway in implementing the former and de facto veto power over the latter. The EU's imminent jurisdiction to harmonize criminal law over human trafficking exposed divisions in member states by bringing opposing conceptions of prostitution as either a form of work or a form of violence against women into direct conflict. The relationship between prostitution and sexual exploitation fundamentally tied the EU's approach to human trafficking to the criminal laws and policies of member states. Countries rushed to revise their prostitution laws ahead of the Amsterdam Treaty coming into force in 1999. The spectrum of state responses to prostitution across the EU in 2000 ranged from legalization regulation, as in Germany, Austria, Spain, Luxembourg, and the Netherlands, to the toleration of prostitution where it was not officially allowed but also not illegal, such as Greece, France, and Portugal, to full-scale criminalization in states where prostitution was illegal, Ireland, for example, to approaches that criminalize the purchase of sexual services to abolish prostitution, as in Sweden and Finland. In 1999, the Commission presented a proposal for a Council framework decision on human trafficking. It focused on sex trafficking, especially from Central and Eastern Europe, although it included labor exploitation within the definition of human trafficking. In 2002, the EU adopted a framework decision on human trafficking as part of its broader agenda to exercise greater authority over external borders in light of the lifting of internal border controls following the Schengen Agreement. Despite a recital characterizing human trafficking as comprising serious violations of fundamental rights and human dignity, the 2002 Framework Decision on Human Trafficking was essentially a criminal law measure that outlined the elements of the crime of trafficking and specified minimum penalties. Its legal basis was the treaty provisions on police and judicial cooperation in criminal matters. The definition of trafficking in the EU's framework decision was based on the UN's Human Trafficking Protocol, which enabled the EU to avoid getting mired in debates about the relationship between prostitution and human trafficking by essentially delegating the resolution or the meaning of exploitation to member states. The framework decision was silent on matters pertaining to immigration, and the protections it offered to trafficking victims were even weaker than the UN's protocol's optional provisions. So there's nothing binding at all about victim rights. Although the EU promised to introduce an instrument more specifically regarding trafficking victims' rights, member states were reluctant to agree to legally binding rules to protect the rights of victims of trafficking who were neither their own nationals nor citizens of the EU. After 2 years of intense negotiation, in 2004, the Council adopted the Resident Permit Directive, based on the treaty provisions allowing the EU to adopt legislative measures in relation to illegal migration and residence. This directive's aim is to strengthen the fight against trafficking. It provides temporary residence permits to third country nationals if they cooperate with criminal law enforcement. The 2002 Framework Decision and the 2004 Resident Permit Directive gave member states a great deal of discretion over how to define human trafficking and the rights granted to victims, while at the same time framing human trafficking as a threat to both the EU's and member states' security. The EU's anti-trafficking initiatives focused on sexual exploitation and prostitution. Migrant prostitution came to be seen as an evil to be combated domestically and internationally. Migrants who were not EU nationals were targeted because the European Court of Justice ruled that EU nationals have the right to work as prostitutes in member states where the activity is not illegal. The Residence Permit Directive provides a humanitarian rationale for deporting migrant sex workers, regardless of the member state's specific stance on prostitution, since they can easily be redefined as victims of trafficking and repatriated to their country of origin in order to protect them. Sex trafficking discourses operated as key elements in the construction of borders in the EU, filtering the flow of people into different legal categories. In 2002, the Commission, the European Parliament, and the International Organization for Migration convened a large, broad-based conference to take stock of the EU's anti-trafficking policy. This conference issued a declaration characterizing human trafficking as a serious violation of victims' human rights as enshrined in international law and the EU Charter on Fundamental Rights and Freedoms. In 2003, the European Commission announced it would use the declaration as the basis of its future work, and it set up an experts group on trafficking in human beings to assist it. The experts group released its report in 2004. According to its president, Marjan Yegers, two themes informed the report: a human rights perspective on human trafficking and a holistic, multi-level, and integrated approach to combating it. Essentially, the report offered a critique and an alternative to the EU's approach to anti-trafficking. It reframed human trafficking as a problem of labor exploitation rather than a problem of illegal migration and prostitution. The report identified restrictive border controls and informal and unregulated sectors in the labor markets of EU member states as contributing to the problem of human trafficking. It recommended legal pathways for labor migration as an essential part of any solution and advocated for the enforcement of labor standards combined with the organization of workers as critical components of any anti-trafficking strategy. The 2004 experts group's report was very influential in shaping the language the Commission used to characterize its approach to anti-trafficking policy. The Commission's 2005 proposal for an action plan on human trafficking referred to the need to have a, quote, integrated approach that has as its fundament the respect of human rights. However, this shared language of integrated approach and human rights obscured different governance strategies based on different approaches to human rights and different conceptions of the harm of human trafficking. Although the Commission's proposal stresses that states' human rights obligations to protect victims, it offered little in terms of concrete victim protection. The Commission also identified labor trafficking as a concern, but it treated the sexual exploitation of women and children as a different kind of problem, warranting a different kind of attention. It was the Council of Europe, the leading pan-European human rights organization, that pulled the EU's governance of trafficking in the direction of human rights. In May 2005, the Council of Europe adopted the Convention on Action Against Trafficking in Human Beings, which stressed human rights and victim protection. The Convention's definition of human trafficking was also based on the UN Protocol, and it implemented some of the measures to protect victims proposed by the EU's 2004 expert group's report. For example, assistance and protection under the Council of Europe Convention hinges on the identification of victims of trafficking and not their cooperation with criminal prosecution. States ratifying the convention are under an obligation to ensure that a national framework is in place for identifying victims and providing them with a period of reflection and recovery. The convention also imposes additional obligations on states to provide benefits and services and establishes a distinctive monitoring mechanism. However, while the Council of European Convention enhances the rights of victims of trafficking beyond what is provided in the UN Protocol and the EU's legislative instruments, none of the rights it provides to victims are justiciable. Victims cannot enforce them via legal action. Moreover, the Convention's approach to protecting the rights of victims of human trafficking is perfectly compatible with the prosecutorial approach of the UN and the EU legal instruments and states' concerns to protect the integrity of their immigration systems. Bolstered by the Council of Europe Convention, the European Commission began to steer the other EU governing institutions towards a more victim-oriented human rights approach to human trafficking. Emerging out of the failed constitutional project, the Treaty of Lisbon was designed to enhance democracy within the EU and to promote European values, including human rights and gender equality for the former socialist countries who are new members. The treaty also authorized the EU to adopt directives harmonizing substantive criminal law with respect to 10 transnational offenses, such as trafficking in human beings and the sexual exploitation of women and children. To assist it in exercising its new human rights jurisdiction and to instill a human rights culture, in 2007, the EU established the European Union Agency for Fundamental Rights to provide independent advice on the rights set out in the EU's Charter of Fundamental Rights and Freedoms. The Commission began the process of revising the 2002 Framework Decision on Human Trafficking by setting up a second group of experts on trafficking in human beings in 2008. The expert group was specifically directed to consider the impact of EU enlargement and the problem of trafficking for labor exploitation. It urged the EU to adopt victims' rights set out in the Council of Europe's Convention, and like the 2004 expert group, the 2000 expert group emphasized the relationship between human trafficking, migration policies, and labor market regulation. In 2011, the EU adopted the Human Trafficking Directive, which repealed the 2002 Framework Decision. The 2011 directive expressed the EU's commitment to an integrated, holistic, and human rights approach to the fight against human trafficking. It went further than the Framework Decision in protecting victims and addressing methods of prevention, cleaving closer to the Council of Europe Convention. However, it did not go as far as both of the expert groups recommended. It also amplified the carceral elements of the EU's approach by expanding the definition of human trafficking, requiring member states to extend their jurisdiction over human trafficking extraterritorially, and increasing penalties for human trafficking. The 2011 directive adopts an individualistic approach to human rights concerned with rectifying the harm to individual victims rather than tackling structural causes of human trafficking. Victim rights are part of a broader carceral agenda that characterizes human trafficking as a form of organized crime linked to illegal immigration. Residence permits remain conditional on victim cooperation in criminal proceedings. The human rights dimension of the directive is weakened by the fact that many aspects of the directive's transposition into national law, such as not penalizing victims for offenses such as prostitution and illegal migration that they may have committed because they were victims of trafficking, are left solely to the discretion of member states. Despite the EU's claim that it was adopting a human rights approach to human trafficking, Neither the 2011 Anti-Trafficking Directive nor the 2004 Residence Permit Directive is a human rights instrument. It is the transnational and criminal nature of human trafficking that is the legal basis for the EU's jurisdiction to enact anti-trafficking legislation. The 2011 directive does not offer trafficked persons from states outside the EU greater protection from deportation than was provided under the 2002 framework decision, although it does provide them with access to a limited set of social rights. The EU's 2012 to 2016 anti-trafficking strategy sought to implement a multidisciplinary, coherent policy. It placed greater attention on labor exploitation and vowed to involve labor inspectors, trade unions, employers' organizations, temporary job agencies, and recruitment agencies in policymaking. This shift towards labor trafficking was a response to the labor market turmoil caused by the 2008 fiscal crisis and a greatly enlarged European labor market composed of member states with profoundly different labor market institutions and outcomes. Stressing the need for labor legislation to regulate migrants working in the EU to prevent human trafficking, the EU's 2012 to 2016 anti-trafficking strategy called for measures to address contractors, subcontractors, and job recruitment agencies in high-risk sectors. There were, however, two big impediments to developing a coordinated strategy to addressing labor trafficking in the EU. The absence of a common understanding of trafficking for labor exploitation in Europe, and member state jurisdiction over most aspects of labor law and regulation. Labor trafficking was neither recognized nor addressed by policy or practice in most European states. The EU Fundamental Rights Agency took up the issue of labor trafficking, and in 2015 it released a report on severe labor exploitation. Its goal was to consider human rights as a legal basis for addressing labor exploitation. It cited Article 5 of the Charter of Fundamental Rights, which prohibits slavery, forced labor, and trafficking, and Article 31, which grants every worker the right to fair and just working conditions as sources of jurisdiction. Conceptualizing labor exploitation as a continuum spanning from slavery to relatively less serious forms of exploitation covered by labor and civil law, it defined severe labor exploitation to include non-consensual and consensual forms of exploitation, which are working conditions where there is a striking disproportion compared with the terms of employment of legally employed workers, which, for example, affects workers' health and safety and which offends against human dignity. I think this is what the German definition of labor exploitation is. Right? It urged member states to implement a comprehensive system of workplace inspections and a mechanism to monitor recruitment agencies. Third parties, such as trade unions, should, it advised, be enabled to act in support of victims of severe labor exploitation. However, because most aspects of labor market regulation fall outside the EU's jurisdiction, all the Commission could do was to pass on these recommendations as policy pointers to member states. A consensus was emerging amongst EU institutions over the need for states to take positive action beyond simply criminalizing specific behaviors to deal with human trafficking. In 2017, the European Court of Human Rights ruled in Chowdhury and others versus Greece that Greece had failed its obligations to prevent human trafficking, protect victims, and investigate those responsible. The case involved 42 undocumented Bangladeshi workers who were threatened with deportation and then shot at after they demanded their wages for their work on a strawberry farm in southern Greece. the court held that states are under an obligation to provide an appropriate legislative and administrative framework to address human trafficking, which includes regulating businesses in addition to investigating and penalizing both forced labor and human trafficking. But despite increased concern about labor trafficking, in 2014, the European Parliament reverted to its historical position of equating prostitution with sexual exploitation, and thus inextricably linked it to trafficking in women and children, when it adopted a non-binding resolution that would criminalize the purchase of sexual services as a way of combating trafficking for sexual exploitation, the Swedish model. That year, the Parliamentary Assembly of the Council of Europe also adopted a similar motion. These institutions favored abolishing prostitution instead of regulating sex work as a way to deal with the problem of sexual trafficking for sexual exploitation. Describing the 2011 anti-trafficking directive as the backbone of the EU's anti-trafficking efforts, in the 2021 to 2025 EU anti-trafficking strategy, the Commission questioned whether the decade-old instrument was fit for purpose and announced that it would be launching a study to evaluate it. However, the Commission was not reconsidering its carceral approach. Instead, it sought to strengthen the criminal law aspects. However, it did want to achieve a better balance between criminal prosecution and protecting victims. The EU's anti-trafficking legislative instruments emphasize transnational crime and movement across borders, because these are the elements that give the EU legislative jurisdiction. With the implementation of the Schengen Accord, which lifted internal borders, member states were concerned that their national borders were only as secure as those of their neighbors. Human trafficking, with its clearly defined victims and villains, underpinned governance strategies to strengthen moral capacities of the state by hardening its borders and by giving state operatives new powers to surveil and assess third country migrants. The EU's turn towards protecting the rights of victims of trafficking was driven by human rights organizations and the increasing institutionalization of European values of dignity and equality. However, the EU's celebrated, integrated, holistic, and human rights approach to the fight against human trafficking was incorporated within and subsumed under a governance strategy designed to amplify the criminal law and to harden the EU and member states' borders to exclude undesirable outsiders. Combating sexual exploitation has been at the heart of the EU's anti-trafficking legislative initiatives, which is understood in profoundly gendered terms and linked to controversial questions about how to regulate prostitution. On the 20th anniversary of the UN's adoption of the Human Trafficking Protocol, the former president of the European Commission's 2004 expert group, Marjan Gieters, confessed that if she and other colleagues who advocated for sex workers' rights had known the history and the inherent flaws of the concept of trafficking back in the 1990s when the protocol was being negotiated, quote, "we would never have used it," quote. In hindsight, she saw how, quote, by falling back on the 19th century Victorian concept of trafficking with its focus on the purity and victimhood of women and the protection of national borders, end quote, she and other sex worker advocates, quote, unwittingly imported a highly biased concept, dividing women into innocent victims in need of rescue and guilty ones who can be abused with impunity, but also with racist and nationalist overtones, end quote. EU legislative institutions have been slower to address labor trafficking, which is considered to involve mostly men and sometimes boys, and to be a smaller, although growing, problem than trafficking for exploitation. Labor trafficking is considered to be only 15% of the problem of the victims of trafficking in the EU. In the EU's most recent anti-trafficking strategy, the Commission recommended the criminal justice response to trafficking for labor exploitation be strengthened. It also promised to introduce a legislative proposal on sustainable corporate governance, to foster responsible corporate behavior, to provide specific guidance on forced labor due diligence, and to consider both the implementation and enforcement of trade agreements to prevent human trafficking and import bans against goods made with forced labor. The EU's legal assemblage of jurisdiction has led to a multifaceted approach to human trafficking that is anchored in preventing and prosecuting cross-border organized crime. The borders demarcating the outside and inside of the EU have created a complex division of jurisdiction over different legal categories of mobile workers, such as free-moving EU citizens, illegal migrants, and victims of trafficking. And each of these categories have very different rights and entitlements and are governed by very different institutions. Victims of trafficking, especially those who are subject to sexual exploitation, epitomize unfreedom, and thus they are the antithesis of what the EU, with its embrace of free movement, is all about. Thanks very much.